Okay, let's go ahead and get started for our final lecture on Louisiana criminal law, procedure, and evidence. Today is the day where we deal with statutory criminal procedure and the code of evidence. Now, these issues are all dealt with on question 3 of the criminal law, procedure, and evidence test. And usually question 3 is comprised of 10 very short questions where you have to answer the question in no more than 2 or 3 sentences. In February, however, February of 2014, the bar examiners only had 5 or 6 questions. So the whole test was a little bit shorter and made it easier to deal with. I hope they do that for you all at the next administration. In any event, what the plan is to spend roughly half the time, or a little more than half the time during this lecture looking at statutory criminal procedure, and then the rest looking at evidence. The split between evidence and procedure on the question 3 is usually, I would say, 60-70% procedure and 30-40% evidence. So we'll roughly do about that with the lecture. Okay, first of all, jurisdiction. Jurisdiction and venue really mean the same thing when you're talking about statutory criminal procedure. And this is all about in which parish the prosecution, a criminal prosecution can be brought. And jurisdiction typically lies in the parish where the offense was committed. If acts constituting offense or if the elements occur in more than one place, the offense is deemed to have been committed in any parish in which such act or element occurred. So, for example, if somebody's in one parish and they shoot over the river and kill somebody in another parish, we have one element, namely the act of the offender, in one parish, and we have another element, the result of death, in another parish. The proper jurisdiction / venue would be either one of those parishes. Special rules for vessels and vehicles in any parish through which the vehicle could have been committed. In a body of water, the boundary of any parish, when it's the boundary of the parish, the jurisdiction of the court of such parish extends to the middle of the river, the thread, as I think you talk about it in property law. An offense committed on the boundary line of 2 parishes or within 100 feet thereof is deemed to have been committed in either parish. If you can't figure out where murder occurred, then the parish where the victim, the body, was found is a proper venue. Identity theft, the parish where the theft occurred or where the victim resides. Okay, what happens if the prosecution is brought in the wrong jurisdiction or improper venue? Again, same thing. What's the proper motion? A motion to quash. And that's a term a motion that we'll talk about several times throughout the course of this lecture, is the motion to quash. That's the proper motion to bring if we've got bad jurisdiction. If you don't raise it, you waive it. Change of venue. Almost always tested. Almost always tested. And we talked about this a little bit yesterday about how you have a constitutional right to an impartial jury. If you can't get a fair trial because of notoriety, publicity, whatever, then the proper motion to file is not a motion to quash because of improper venue. The venue is proper, but motion to change venue. And what's the court going to look at? Everything you would imagine: nature of the publicity, the notoriety of the offense. You don't have to memorize these factors. All you're going to be asked on the bar is what do you do if there's been unfavorable pretrial publicity? And the answer is you're going to file a motion for change of venue. Nothing more than that. Okay, so we've talked about jurisdiction and venue, geographically speaking. Now let's talk about subject matter jurisdiction of courts. District courts have original jurisdiction over state felonies and misdemeanors. Mayor's courts have original jurisdiction over ordinance violations. Justices of the peace do not have jurisdictions to try any cases except for those involving littering. Parish and city courts, again, never been tested, but there it is for you to look at. Appellate jurisdiction. Appeals from district courts go directly to the Louisiana Supreme Court only if we're dealing with a situation where we've got a death penalty imposed or a statute or ordinance has been declared unconstitutional. That's it. Those are the only times you go directly to the Louisiana Supreme Court on appeal. Other cases, appeals from the district courts and other cases triable to a jury go to the appropriate court of appeals. Appeals from parish, city, or mayor's court go to the district court. Generally, the trial court loses jurisdiction upon entering an order of appeal, except to correct an illegal sentence or to impose a habitual offender sentence. Inherent powers of courts. All courts possess inherent contempt power, and contempt is conduct that tends to obstruct or interfere with the orderly administration of justice. All you really need to know is there are two kinds of contempt. Direct contempt, that occurs right before, in front of the judge. The judge can, for example, if somebody won't shut up, the judge can hold that person in direct contempt and punish him right then and there, summarily. If the conduct is not observed by the judge, and usually it's somebody's violated a court order, then that's constructive contempt, and then the court's got to issue notice of a hearing and hold a hearing. Can't summarily impose punishment. That's all you really needed to know. Direct contempt versus constructive contempt. Pretrial procedures. Search warrants, we've already kind of talked about all that, and this stuff is only really tested when on the constitutional criminal procedure test, so we're not going to talk about warrants. We're not going to talk about property. Who can execute a warrant? This is up at the top of page 4. A warrant may be directed to any police officer who must execute it and bring any property seized into the court issuing the warrant. Police have to give a receipt for the seized property to the person from whom the property is taken. People can be, you can get warrants for the search of a person and sampling of DNA. Again, never been tested. Arrest. Okay, here is one of these situations where we have a slightly different take on things in Louisiana than under the federal Constitution. We'll see this in maybe two situations, and here's one of them. Yesterday we talked about how the police need probable cause to arrest you. And an arrest occurs when the cop lays hands on you and physically restrains you. Obvious. Handcuffs, sits on you, holds you. Obvious. But also, if the police officer orders you to stop and you submit to his show of force. Again, under federal principles, that constitutes a stop. Could be an arrest depending on how long he takes you. Could be just, it's something that constitutes a stop for which the Fourth Amendment requires a justification, either probable cause or reasonable suspicion. In Louisiana, citizens have more rights, and that is police need a justification not only for stopping you, for making you, for physically stopping you or ordering you to stop when you stop, but also when they are imminently going to stop you. That means that when they're chasing you and they're close. At that point, if you throw down some drugs or something, or then it could be that the imminent actual stop has occurred, which is when the police attempt to seize a person, but you don't submit and you're not physically touched. The focus is on the degree of certainty that the suspect will be stopped. So under these circumstances, you may have Fourth Amendment, equivalent of Fourth Amendment rights under the Louisiana Constitution. We know what probable cause is. We've talked about that. We've talked about warrant affidavits. Talked about the execution of warrants. One thing that is important is that a warrant may be executed by any police officer who has authority within the territorial jurisdiction where the arrest is to be made. So, obviously, an East Baton Rouge sheriff's deputy can't go arrest somebody in New Orleans. However, if he's in close pursuit of an arrestee, he can enter another parish to effect an arrest. There are rules about private arrests that, with regard to a felony, you can make a citizen arrest as to any felon. And then there are special rules that deal with shoplifting, merchants, and I'm not going to get into that because it's never been tested, but there it is. Just understand that there are special rules that allow merchants to arrest shoplifters, to detain shoplifters. When is a warrant needed for an arrest? We talked about the constitutional standards for that a couple of lectures back. What about under the Code of Criminal Procedure? A law enforcement officer may arrest a person without a warrant if the officer has probable cause to believe that the person has committed a crime. Now, also keep in mind that probable cause is determined from, and this is an important sentence here, so put a little star next to it. Louisiana Supreme Court has held that even though a police officer individually did not believe that he had probable cause to make an arrest, if he actually arrested the defendant and there was collective knowledge on the part of the police to support probable cause, the arrest is lawful. So that's an important concept. In determining what information the police have, you look to the knowledge of all police officers, not the arresting officer. Subjective belief or attitude of a particular officer is also irrelevant. We've talked about that. Pretextual stops and arrests are okay as long as the officer or officers collectively have enough information to rise to the level of probable cause. Of course, you need warrants to enter, as we've talked about over and over again, to enter a residence. Next page, stop and frisk. We've already talked about that. Traffic stops. A police officer can make an arrest for a misdemeanor committed in his presence. We've talked about that. Just ignore all this stuff about when driver not. We've talked about that. Booking. Okay. After you are arrested, you're put in the back of the police car and you're taken downtown to the whatever the holding facility is. At that point, you are booked, and that means that you are informed of the charges against you. You're informed that you have a right to get and talk with a lawyer, and that you have a right to a preliminary examination if charged with a felony. At this point, you don't have the right to an appointment of a lawyer at booking. That comes later. If, of course, they want to interrogate you, you have a Miranda right to counsel, which we've talked about before. After you are booked, they give you what's known as a booking information summary, which is a piece of paper that just lays out your name, the charges, short statement of the facts, who else was arrested, and anything else. Extradition, never been tested, but this is where, if somebody from Mississippi has committed a crime in Mississippi and they're arrested here, how they are shipped from here to Mississippi. And they're entitled to a hearing, but the hearing is limited to really just whether this is the same guy wanted in Mississippi. And they don't get into any more detail than that. And that's what this says. At an extradition hearing, a court may not re-examine probable cause for the arrest which underlies the charge in the state seeking the person. And some of this is implementing the Federal Extradition Act, which we don't need to talk about. Okay, next page. Right to counsel. We talked yesterday about your Sixth Amendment right to counsel. And, of course, a defendant in a felony case, under Gideon versus Wainwright, has a right to counsel at all critical stages. But what about misdemeanor cases? And here is, in your criminal procedure class, you might have talked about Argersinger and some cases that talked about when you get a lawyer in a misdemeanor case. In Louisiana, it's easy. The Louisiana Constitution makes no distinction between felony and misdemeanor cases and provides that if a sentence of imprisonment is authorized, the right to counsel attaches. That's a nice, simple rule. If it's authorized, you get a lawyer, period. Capital cases, you get a lawyer who's got at least 5 years of experience. You can waive, as we've talked about, your right to counsel and assert your Ferretta right to self-representation. However, the court's got to go on the record and engage in a colloquy. When does the right to counsel attach? At the first court appearance or judicial hearing, even before indictment. So just at the commencement of formal judicial proceedings. That's your first court appearance. This is an important time frame to know, just 72 hours. Within 72 hours, you've got to be brought before a judge for the appointment of counsel and for the setting of bail. Do you have a right to a lawyer at a grand jury proceeding? A witness who's a target can have his lawyer present. Lawyer can't do anything. The lawyer can just come and watch. But if you're a target, then you have that right. Confessions. This is we're not talking about Miranda and all that sort of stuff, but Louisiana follows the common law rule of corpus delicti, which means that suppose you show up and you tell a police officer, look, I've killed 5 people. And that's all they got, you admitting to it. They don't have any dead bodies. They don't have any videotape surveillance of you killing people. They got nothing other than your confession. Can you be convicted? Technically, no. Louisiana follows that corpus delicti rule. There must be proof independent of a confession to establish the existence of a crime. And that's it, that. Motions to suppress. A defendant may file a pretrial motion to suppress evidence unconstitutionally obtained or inadmissible for some other reason. And this is important, standing. Remember I told you to scratch out all that stuff in this standing under the Fourth Amendment when we talked about that in an earlier lecture? Why did I ask you to do that? Well, because of this. In Louisiana, any person adversely affected by a search and seizure has standing to raise its illegality. So that's an expanded view of standing in search and seizure cases. So it allows you to try to seek the suppression of evidence that violates someone else's reasonable expectation of privacy, even though you had no reasonable expectation of privacy. That's an important concept in Louisiana, much broader than under the federal standards. Motion to suppress procedural aspects. You got to file your motion to suppress within the usual pretrial limits, which is, and this is one of these time frames you just got to remember. But it's easy because it's the same for virtually everything. 15 days. You got to file your pretrial motion to suppress within 15 days of arraignment. Arraignments, that's when you show up and answer the charges and enter a not guilty or a guilty plea. The state has the burden of proving the admissibility of a confession beyond a reasonable doubt. If it's a warrantless search, the state has the burden of showing probable cause and which exception to the warrant requirement applies. All other cases, the defendant has the burden of proof. Defendant can testify without being cross-examined on other matters. We've talked about that. If you don't file a motion to suppress, you waive it. An adverse ruling and a motion to suppress, binding at trial. Next page. Identification evidence, we've already talked about that. Preliminary examination. Now, what is this? If you are arrested on a felony charge, this doesn't apply for misdemeanor charges, but on a felony charge, you have a right to a preliminary examination, which is really a full-blown hearing at which you can call and subpoena witnesses, and the judge is going to sit there and listen to the witnesses. And what's the purpose? Well, the purpose is to either, well, it depends on whether you're talking about pre-indictment or post-indictment, or pre-indictment or post-indictment. If it's before indictment, it's all about determining probable cause. If it's after indictment, there the grand jury has determined that there's probable cause, then it's only about perpetuating testimony and fixing bail. Okay, suppose you have not been indicted and you're under arrest for murder, and your lawyer files a motion for a preliminary examination and starts subpoenaing witnesses, and it looks to the judge like they got the wrong guy. What happens? He finds that there's no probable cause to bind you over for trial, is what they call it. And at that point, you're released from custody. Can they still indict you? Yes. Can you still be prosecuted later? Yes. But you're released from custody. The United States Supreme Court in Gerstein, which we mentioned in an earlier lecture, requires that there's got to be a probable cause determination not later than 48 hours after arrest for those arrested without a warrant. And here, after you are arrested, the police officer has got to submit an affidavit of probable cause to a magistrate, and that needs to be looked over, and the magistrate needs to confirm that there's probable cause for the arrest. Bail. In Louisiana, you have a constitutional right to bail. However, depending on the circumstances, bail can be denied because you might be a flight risk or something. You have a right to a contradictory hearing. In capital cases, bail is neither required nor prohibited. You can get bail after conviction, but only if the offense is punishable or the sentence imposed is less than 5 years, and not if the court finds that you're dangerous. Who can fix bail? District judges, city and parish judges in non-capital cases, and some other judges in various other cases. Felony cases, bail is set individually. In misdemeanor cases and non-capital felonies, except in Orleans Parish, bail schedules are permissible. What factors are considered in setting bail? I'm not going to read all these to you, but it's fairly obvious, right? The strength of the evidence, the dangerousness of the offender, the flight risk, prior criminal record, those sorts of things. Again, I wouldn't memorize all that stuff. It's going to be fairly obvious if they ever test you on bail, which they really never do, that what sorts of things would be, what facts would be relevant in setting bail. It's pretty intuitive. Bail can be increased or decreased after it's originally set. Judge can impose conditions in addition to bail. Methods of satisfying bail. Surety bonds, that's when a bail bondsman puts up a surety bond. Personal surety or property bond is when you put up your own property. Cash bond is when you put up cash. A PSBU, a personal surety bond undertaking, is essentially a release on recognizance. Exclusions. This was tested once, and it's also just nice that lawyers can't be sureties. So your client can't say, "Hey man, would you help me with my bail?" You then have to just shrug your shoulders and say, "Look, boy, I'd love to help you, but I just can't help you, man, because lawyers are excused or excluded from that." Okay, instituting prosecutions. This is tested every now and again. And this is what you need to know, that offenses punishable by death or life imprisonment, the most serious crimes, murder, aggravated rape, aggravated kidnapping, can only be commenced through grand jury indictment. The grand jury refused to indict you, the DA cannot do it. Every other prosecution can be commenced either by bill of information or by bill of indictment. Okay, what are these documents, these charging instruments? An indictment is a written accusation of a crime by a grand jury. Requires 9 grand jurors to sign on to it. They endorse it as a true bill, and the foreperson signs it. A bill of information, in contrast, is just a written accusation of a crime made by the DA. An affidavit is a written accusation of a crime made under oath and signed by the affiant, usually a police officer. Failure or refusal of the grand jury to indict does not preclude a subsequent filing of indictment, information, or affidavit. But of course, if it's a crime can be commenced only through indictment, then another grand jury can maybe indict, but not this one. But otherwise, the prosecution won't go forward. Prosecutions in district courts may be initiated by indictment or information, unless, of course, it's one of those crimes that can only go forward on indictment. Grand and petit juror requirements. To be a juror, and oddly enough, this was tested once, but you got to be 18 years old, you got to be able to read, write, and speak English, not under interdiction, not be under indictment or convicted of a felony, and be a U.S. and Louisiana citizen who resided in the parish for 1 year. Grand jury. Grand juries have 12 people plus 12 jurors plus 2 alternates. 9 are required to indict. Grand jury proceedings are secret. Who can go in the room? The district attorney, the prosecutor, basically, witnesses, court reporters, and counsel for a target. Grand jurors have to keep their mouths shut about what happens inside. A witness, however, can walk out and discuss testimony. Sufficiency of indictment or information. An indictment has got to be, or information, has got to have enough information to tell the defendant what he's charged with and to enable him to enter a plea to the charge and define the parameters of relevancy of evidence at trial and protect the defendant against double jeopardy. So, I mean, it doesn't have to have a lot of information, but it's got to say, for example, the defendant did rob a pedestrian at the corner of Highland and Dalrymple on January 3rd, 2014. Well, again, it tells you who did it, tells you where it happened, tells you when it happened. So, pretty much notify the defendant of what he is charged with, the who, what, where, and when type information. Suppose the prosecutor doesn't have all that information in the bill of indictment. It just says that the defendant did commit armed robbery in the parish of East Baton Rouge. Well, that doesn't really, it tells you what you're charged with, but it doesn't really give you sufficient information to define the parameters of relevancy at trial. I mean, you may have committed a bunch of armed robberies. You don't know which one this is for. So what do you do then when you don't really know which armed robbery they're talking about? Well, then you file a motion for a bill of particulars. And you file that pretrial motion, and you ask for who, what, where, when type information, very basic information. This is not for purposes of discovery, although you learn about the case, so it is kind of discovery-like. You can't get who the witnesses are, but you get just more basic information about where the crime was committed. So this is often tested. They will ask you on the bar, what you would do if you had a bill of information or a bill of indictment that didn't really tell you much about the crime. Your answer is you would file a motion for a bill of particulars. This is another thing that's been tested, the amendment of indictment. And the way it's been tested is, suppose that they charge that the crime happened on January 3rd, 2014. Turns out that the crime really didn't happen after midnight. It happened at 11:30. So it really happened on January 2nd. What about that? Well, mere technical errors do not invalidate an indictment. It can be amended at any time to correct technical errors. Errors of substance may be amended prior to trial. If the indictment is amended prior to trial, the defendant can move for a continuance. If the error is discovered after trial commences, the court must order a mistrial. If the defendant fails to raise the error at or before trial, no conviction is going to be set aside absent a showing of actual prejudice. Joinder of offenses or offenders in the same indictment. Often, very often tested. So you can see this is a little odd stretch that we're hitting here in this outline. When we're talking about the charging instrument, its sufficiency, defects in the charging instrument, often tested. I don't know why they do that, but because it doesn't, in real life, these problems don't come up that much. But you ought to put stars on this page because here this stuff matters. Okay, let's talk about joinder of offenses. Suppose that you've killed a couple of people, you've stolen some bubble gum, you've kicked a few dogs. You're kind of a bad person. Can they lump all the stuff together in the same bill of information or bill of indictment? That's what this is all about. The state may join two or more offenses in the same indictment in a separate count for each offense if they are of the same or a similar character, or they are based on the same act or transactions, or two or more acts or transactions connected together as part of a common scheme, and they are triable by the same mode of trial. Well, so for example, suppose you've got lots of thefts all over town, bubble gum, cars. Those are all of the same or a similar character, so they can be charged together as long as they're triable by the same mode of trial. That is, tried by a jury of 6 or a jury of 12 or a judge. You'll see when we get to this that the more serious the crime, for murder, you need 12 people. You can't try it with a 6-pack jury. You have to have 12. So if the prosecutor is going to join together a bunch of offenses, they have to be similar or based on the same transaction or occurrence. And they've got to be triable to the same finder of fact, whether it's 12 jurors or 6-pack juror or the bench. That's important to know. When can two defendants be joined for trial? And again, fairly simple. If two defendants have participated in the same act or series of acts, they can be joined together. They both went into the bank together, they can be joined together in the same indictment. Now here is the very ripe area of testing, misjoinder. What do you do about it if the DA joins together offenses or defendants in the same indictment that shouldn't be joined together? Well, this is what you do about it. At that point, you have misjoinder, and you file a motion to quash. That's what you need to know. You need to know those two words, misjoinder and motion to quash. Try to quash the indictment for misjoinder. Now, suppose the DA has properly joined together defendants or offenses, but some prejudice is going to result from a joint trial. There's no misjoinder, so you're not going to file a motion to quash, but what you're going to file is a motion to sever, to try the defendants or the counts separately. So what's this bad man taint paragraph here? I don't know why it's stuck here, but it's not a bad place for it. this is the point. The point is that as to one count, it may be that there's a lot of 404B evidence, that is, prior acts, bad acts, that are probative of your intent or knowledge that are admissible as to one count, but they're not admissible as to another count. So the concern is that all of this prior bad conduct, 404B type evidence, is going to come in for one count, but it's not going to be relevant to the other counts, but it's going to slop over. And the concern about slopping over evidence that's relevant as to one count but not to another might be a reason for a motion to sever those counts for separate trials. And that's all there is to that. Severance of defendants, same thing. For example, we talked about this, the Bruton rule. If one of the defendants has confessed but the other hadn't, you're probably, almost certainly, going to sever their trial, so the defendant who did confess will have his confession used against him, while the other one, the other defendant, at his trial, there will be no discussion of the missing co-defendant's confession. Pretrial attacks on the indictment. Again, this is something that's important, that's tested. When do you have to file them? Again, this is your one important period, 15 days after arraignment. And you raise all of these via a motion to quash. Top of page 15, when can you not make a motion to quash? To test the sufficiency of the evidence. There is no procedural device for testing the sufficiency of the evidence. And this is something that I can't tell you how many times when I was doing clinic at Tulane and Broad in New Orleans and representing people with students on cases that the clients would say, hey man, I didn't do this crime. I didn't do it. You got to file a motion to squash. And we'd say, well, we can't file a motion to squash for that. There's no defect in your indictment. You just say that you didn't do it. That's what the trial is all about. You get to come to the trial and tell the judge or the jury that you didn't do it, and they'll decide. But you don't resolve or test the insufficiency of the evidence through a motion to squash. Time frame for filing the motion to quash, there again, 15 days from arraignment. What are the grounds for a motion to quash? And again, these are all problems that jump off the face of the indictment. Not that relate to evidence, but they jump off the face of the indictment or the bill of information. The statute is invalid because it may be unconstitutional, for example, that your client is being prosecuted for. The indictment is in the wrong form. The indictment is duplicitous because it charges more than one offense in one count, or there's misjoinder. The DA didn't give you a bill of information when he was ordered to do so. A bill of particulars, I'm sorry. The bill of particulars show that no crime was committed or the defendant didn't do it. Again, if somebody else other than the defendant at the bar is mentioned in the indictment. Double jeopardy. Statute of limitations is run. Undue trial delay. Again, all stuff that jumps off of the face of the indictment. No jurisdiction. So, again, if you just keep in your mind that's what the motion to quash really is all about, that needs to be filed within 15 days of indictment. It's all about facial defects in the indictment, jurisdictional problems, those sorts of issues. Also, for example, problems with selecting the grand jury, again, because that shows a problem with the indictment. Problems with the grand jury proceedings. Bill of information not signed. Again, this is just technical defects. That's what you need to know. Okay, so the charging instrument has been filed, either the bill of information, bill of indictment, whatever it is. Then the arraignment happens. At the arraignment, you're holding the bill of information or the bill of indictment, and you have to enter a plea. You've got to do it in person if it's a felony case. If it's a misdemeanor case, your lawyer can do it. What are the pleas? Guilty, not guilty, or not guilty by reason of insanity, or nolo contendory. We've talked about those, nolo contendory, and we've talked about not guilty by reason of insanity as well. At guilty pleas, we've already talked about this. You've got to be boycotted. You've got a right to a lawyer. In a capital case, you can't plead guilty and get death. You can plead guilty only if the DA removes death as a possible punishment. You can't plead guilty within 48 hours of arrest in a felony. If you plead guilty, you're waiving non-jurisdictional defects in the proceedings. Time limitations. All right, well, here there are a number of mind-numbing limitations that I don't recall them ever being tested. Standing here today, thinking back 10 years, but you never know. It's so easy to test something like this because, and they do it all the time on the Louisiana Code of Civil Procedure exam, because you can just easily get somebody to give a right or a wrong answer on this. So again, I think you need to know it, but like I said, it's never been tested. Okay, so from the time of the crime to charge, how long does the state have to institute the prosecution? So suppose you murder somebody today, or you rob a bank today, or you purse snatch somebody today. When are you out of the woods? When can the state no longer charge you? That's really this question. If it's a capital or a life imprisonment crime, forcible rape, no time limit. You can be charged for that whenever. For a felony that is necessarily punishable by imprisonment and hard labor, which is the most serious felonies, 6 years from the offense. For a felony not necessarily punishable by hard labor, 4 years. If it's a sexual offense against a victim under 17, 30 years from when the victim becomes 18. If it's a misdemeanor, punishable by fine or imprisonment, 2 years. If it's a misdemeanor punishable only by a fine, 6 months from the time the offense is committed. Interruption, that is when the clock stops and restarts, the period begins to run anew. If the defendant flees from the state, what did I do here? Flees from the state, I need to take a little nap here. Time limit for commencing trial. Now this is a different time limit. This is for when what we just talked about is from the time the crime is committed to when they have to charge you. This time limit deals with after you're charged, when they have to bring you to trial. In a capital case, they got to do it within 3 years from institution of the prosecution. In a felony case, 2 years from non-capital felony case, 2 years from institution of the prosecution. In a misdemeanor case, 1 year from institution of the prosecution. If the defendant ever fails to appear, then the time period begins to run anew. It's interrupted. Suspension of time limitation. When the defendant files a motion to quash or for change of venue or other preliminary plea, the running of time is suspended until the court rules on the motion. If you have a mistrial, they have to bring you to trial within 1 year unless there's still time left on the original clock. The Louisiana Speedy Trial Act sets forth a number of time periods that deal with various issues. For example, after you are arrested, when you are in custody, they've got to charge you within 45 days of the arrest for a misdemeanor, or 60 days for a felony, or 120 days, within 120 days after a felony punishable by death or life imprisonment. If you're not in custody, 90 days for a misdemeanor, or 150 days after arrest for a felony. See what I mean about mind numbing? It's just hard even just to read this. Delay, once you are indicted or a bill of information has been filed, you got to be arraigned within 30 days. Once the defendant files a motion for a speedy trial, trial's got to be commenced for a misdemeanor within 30 days if in custody and within 60 days if not in custody. Charged with a felony, trial's got to start 120 days if you're in custody and 180 days if you're not in custody. Defendant has been released because proceedings were not timely instituted, may be rearrested if proceedings are subsequently commenced. The defendant acquiesces in the delay. There is a credit day to day in the time limits. Okay, let's go ahead and take a break for 10 minutes and then come back and pick up on page 19 with mental incapacity to proceed. Are we ready to resume? All right, well, as we left off, we were getting ready to talk about mental incapacity to proceed. And, you know, we've already spent a little time talking about that, so I'm not going to talk about it in any great detail. But this all deals with not insanity at the time of the offense, but with mental problems that impair the defendant's ability to understand the nature of the proceedings or to assist in his own defense. What happens when that issue is raised? Well, the court orders a mental examination and appoints a sanity commission. You just need to know that term, sanity commission, which is 2 or 3 psychiatrists who examine the defendant and then report back to the court about whether they think he can understand the proceedings and assist in his defense. If after a contradictory hearing is held, the judge finds that the defendant is incapable, he is shipped off to an institution where he is medicated and given therapy, and when he is well, then another contradictory hearing is held and the judge determines that the proceeding can go forward. Next page, as to exculpatory insanity at the time of the crime, same kind of sanity commission is often appointed. And the issue is tried to either the judge or the jury, and the defendant has the burden of proving insanity by a preponderance of the evidence. However, if the DA and the defendant agree, then the court can adjudicate the defendant not guilty by reason of insanity without a trial. If the defendant is found not guilty by reason of insanity, in a capital case, the defendant is committed to a state or private mental institution. In other cases, there's a commitment proceeding that's held to determine what should happen with him. It's all about whether he's presents a threat of harm to himself or to others. Recusal. Now, for some reason, this is tested occasionally. And it's pretty straightforward. It's usually the last grounds for recusal that comes up on the test, which is the judge must be recused if for any reason he's unable to conduct a fair and impartial trial. Pretty obviously intuitive standard, right? So you should be ready to tell the examiner that you know that the judge should be recused if he is unable to conduct a fair and impartial trial. There are also grounds there that if he's biased, prejudiced, or personally interested, if he's closely related to the accused, the defense lawyer, or the DA, if he was involved in the case as a lawyer or was associated with a lawyer involved in the case, if the judge is a material witness or has performed a judicial act in another court. Again, I guess you should know those grounds, but the most important one is the last one. If for any reason he's unable to conduct a fair and impartial trial. DA can be recused if he's got a personal interest related to the defendant, the victim, or has been employed or consulted in the case as a lawyer. DAs at any point, they have virtually unbridled discretion in this regard, can dismiss an indictment or bill of information without the consent of the court. Consolidation, this is the opposite of severance. This is when you are charged in 2 or more indictments and you want to be tried together in the same proceeding. That's a motion to consolidate. Continuance, this is tested every now and again. Again, the question is fairly obvious, is that you're not ready for trial. What do? Well, the answer is pretty simple. You file a motion to continue. And a motion to continue has got to be in writing. It's got to state the grounds for which it is sought and must be filed at least 7 days before trial unless there's good cause for filing it later. It's a matter that is submitted to the discretion of the district court. Discovery. If the defendant moves for discovery, the court has got to order the DA to turn over these things. And you need to know these things. The defendant is allowed to inspect and copy any written or recorded confession or statement that is in the possession of the DA. As to oral statements made by the defendant is entitled to know about their existence, but not necessarily their contents, and when, where, and to whom the statement was made. If the oral statement was made to a police officer, then the defendant gets to know about the substance of the statement. Also, the defendant is entitled to get a copy of his rap sheet. Now those are as to kind of confessions, rap sheets. Next, documents and tangible items. What does the defendant get if he asks for them in discovery? He gets Brady information favorable to the defendant and relevant. 2, he gets the state's exhibits. 3, he gets his own stuff, whatever information was obtained from him. The state doesn't have to preserve evidence unless the evidence might be expected to play a role in the defendant's defense. The defendant can't object to the destruction of evidence as prejudicial unless the state possessed evidence that was apparently exculpatory before it was destroyed, and the defendant can't get comparable evidence elsewhere. What else does the defense get? Reports of examinations and tests. Kind of any lab tests or fingerprint analyses that the DA intends to use at trial or that are exculpatory. That's Brady, of course. Other crimes evidence, this is 404B. The defendant's entitled to know what other crimes evidence the state is going to use against him. He gets, if he moves forward, of course, notice of its intent to use co-conspirator hearsay, and also confessions and inculpatory statements of co-defendants. What do you not get if you're the defendant? You don't get work product of the DA. You don't get supplemental police reports. You don't get witness statements. And of course, you always, at the top of page 23, get Brady information. We talked about that yesterday. Now, if the state moves for discovery, the defendant is required to disclose documents, reports of examinations, and whatnot that he intends to use at trial. If he intends to put on evidence of his mental condition, he's got to notify the state at least 10 days in advance of trial. If the DA makes a proper demand within 10 days, the defendant's got to give the DA notice of his alibi. Trial. You know the order of trial. I don't need to tell this to you. Never been tested. Opening statements. Defendant doesn't have to give one. The state can't refer to the defendant's confession unless the statement was previously ruled admissible in the case. Miscellaneous rules. Sir, rebuttal is optional or discretionary. Next page. Defendant has a right to confront and cross-examine witnesses. We talked about that. Criminal cases have got to be randomly allotted among the judges. Yes. Jurors can take notes only if everybody agrees in open court outside of the presence of the jury. Oddly enough, it's DAs that don't want jurors to take notes. But everybody's got to agree for them to take notes. Right to a public trial, we've talked about that. Mistrial, we talked a little bit about this, but there are in Louisiana there are certain mandatory grounds for mistrial, including if the judge, DA, or other court official refers to race, religion, color, or national origin, if the comment is not relevant to the case and might create prejudice. If anybody refers to another crime committed by the defendant that is not admissible, if anybody comments on the failure of the defendant to testify, or the refusal of the judge to direct a verdict, mandatory mistrial. Admonition is insufficient unless the defendant agrees. As to other prejudicial comments, the judge can admonish the jury to disregard them. Now, this is important, comment by the judge. In Louisiana, the judge cannot comment on the facts. The legislature wants to take judges kind of out of the fact finding. Jurors find facts, the judge can't comment on them, can't recapitulate the evidence, repeat testimony, or give an opinion of what has been proved. Arguments got to be confined to evidence, yeah. Other grounds for mistrial: defendant consents, hung jury, lack of mental capacity to proceed that develops during trial, defendant's physically unable to proceed, just kind of things that would be obvious. Motion for judgment of acquittal. This is somewhat important. Suppose the the prosecution puts on no evidence that there's a dead body, that anybody died in a murder case. Remember, we talked about that earlier. Can you stand up if you're the defendant and ask for a judgment of acquittal, because it's kind of like a directed verdict, because there's been no proof on that material element? Well, Louisiana does not allow a directed verdict in jury trials. In a non-jury trial, the defendant may move for a judgment of acquittal after the close of the state's evidence. Now, after the jury comes back, you could file a post-verdict motion for a post-verdict judgment of acquittal, but we'll get to that in a second. But we want juries to decide the issue. Right to a jury trial. In a capital case, you have to have 12 jurors, and they have to be unanimous to render a verdict. In a case necessarily punishable by hard labor, you have to have 12 jurors, 10 of whom must concur. If it's a felony case in which punishment may be confinement at hard labor, you can do it with 6 jurors, and unanimity is required. Misdemeanor cases can be tried to 6 jurors. Unanimity is required. Can you waive a jury trial? Yes. A defendant, except in a capital case, can knowingly waive a jury trial. And the court should advise the defendant of that right at arraignment. Now, keep in mind, this is a little unusual, that a defendant can waive a jury trial, but the state can't, and the state can't force a jury trial on a defendant. It's different in the federal system, but in the state system, if the defendant wants to be tried by a judge, he can just make that decision on his own. The parties have a right to voir dire prospective jurors. When a jury, sequestration of jurors, when a jury is sequestered, they're kind of kept together. In capital cases, each juror that is sworn, you have sequestration from the swearing of the jurors, not just when they're deliberating, as is the case when they are in non-capital cases. Challenges to prospective jurors. This has been tested before, oddly enough. Peremptory challenges of jurors must be exercised prior to the swearing in of the jury panel and must be made and communicated to the court at sidebar. So anytime up until the swearing in of the jury, you can exercise a peremptory if you haven't used them all up. So that's important to know. Challenges for cause include lack of qualifications, bias, anything. It'd be fairly obvious if you ever tested on that. Number of peremptory challenges in capital cases and cases necessarily punishable at hard labor. Each party has 12 challenges. In all other cases, each party has 6 challenges. Presence of the defendant. In felony cases, the defendant must be present at all significant stages of the proceeding, and if the defendant voluntarily absents himself, then the trial could go on. You have a right to present a defense. You have a right to compulsory process of witnesses. Defendant can subpoena witnesses, of course, at his own expense and at state expense, a limited number of witnesses. Defendant can get experts at the state's expense. Next page, 28. Of course, there's presumption of innocence. Long list of responsive verdicts in the Code of Criminal Procedure. There's no way really that they could test on those. Sentencing, we have sentencing guidelines that are not really followed very often. They are not mandatory. Sentencing judge has got to say that he has considered them, but again, they're not mandatory. Court must order restitution to the victim and may order restitution to others. Sex offenders, child predators must register with a sheriff of the parish in which they reside. Post-conviction procedures. Okay, now this is tested. And the call of the question is usually they present some issue and the question is what motion are you going to file? Well, we've already talked about the motions that would challenge the sufficiency of the indictment or the bill of information, right? So if it's one of those things, you're going to file a motion to quash. You can't file a motion for judgment of acquittal during the trial, unless it's a bench trial and the state's rested. But if it's a jury trial, the judge is not going to take the issue from the jury just because the prosecutor didn't put on a material element. So now we talk about what happens after the jury's come back and your client's been convicted. If he's been acquitted, then of course he goes free and double jeopardy precludes his retrial. But if he's been convicted, what sort of motions do you want to consider? And that's what this is all about. Well, first of all, is a motion for new trial, just a do-over. And you ask the court, and you file this before sentencing, and the court must grant a motion for a new trial when the verdict is contrary to law and evidence, if there's prejudicial error, there's been newly discovered evidence, some prejudicial error, or the big catch-all, justice so requires. So this is what you usually file when you just think the jury got it wrong. So you just argue, the jury got it wrong, give us a new trial. Or we got some new evidence that we couldn't have found earlier, give us a new trial. Grant of a new trial permits retrial, and there is no double jeopardy. Okay, next motion to consider filing is a motion for post-verdict judgment of acquittal. The jury's come back now, right, and convicted your client. The defendant may move for a post-verdict judgment of acquittal before sentencing. The court should grant the motion if viewing the evidence most favorable to the state, it's that same Jackson standard we talked about earlier. It finds the evidence does not reasonably permit a finding of guilty. If the trial court finds that the evidence supports only a conviction of a lesser included or responsive offense, it should modify the verdict to so reflect. Now, if the trial court finds, for example, that there was no evidence on a killing in a murder case, the judge should grant a motion for post-verdict judgment of acquittal. Can the state appeal that? Yes, the state may obtain review. If the trial court enters a judgment of acquittal, the appellate court may reinstate it. No double jeopardy problem here because no need for retrial. However, the appellate court sustains the judgment of acquittal or sets aside a conviction, the defendant may not be retried because of double jeopardy. That's a post-verdict motion for judgment of acquittal. Motion for arrest of judgment. The defendant may move for an arrest of judgment before sentencing. What's the standard? The same that exist for, generally, the same that exist for motions to quash, procedural technical defects. Right? The indictment is defective. The offense is not punishable under a valid statute. Court doesn't have subject matter jurisdiction if it's not waived, or geographic jurisdiction if it's not waived. Wrong mode of trial, verdict not responsive, improper charging document. Again, if you think of motion and arrest of judgment as just the post-verdict version of a motion to quash, then you're in the right place. Last motion to think about is a motion to reconsider sentence. And then you're just asking the judge to, the judge has imposed a 10-year sentence, you're saying, Judge, can you think about that again and maybe impose only 5 years? That's all there really is to that. Appeals, page 31. And notice I'm not going into a lot of detail here because a lot of detail is not required. Your answers for these are very short, and you're mostly just showing that you know what the proper vehicle is to fix a mistake, whether it's a motion to quash, post-verdict motion for judgment of acquittal, a motion and arrest of judgment. Again, once you show them that you know what the right vehicle is, you don't have to go into much detail. Appeals. An appellant has 30 days from the rendition of the judgment or ruling on the motion to reconsider the sentence in which to make an oral or written motion for appeal. That's how you initiate an appeal of a criminal conviction, by a motion for appeal. Only final judgments are appealable. The state, of course, may appeal a ruling and a motion to quash, etc. Defendant may appeal from a judgment or a ruling declaring the defendant insane. If there's no right to appeal, then you can seek review by way of writs. That's a discretionary form of review, not a basis. You have no basis or right to review by writ. Standard review on appeal. If all the evidence is insufficient to support a conviction, the defendant must be discharged. Post-conviction relief. We mentioned this before. This is collateral review. You can file this not more than 2 years after the judgment of conviction has become final, unless facts arise that were not known to the petitioner, or it's based on an appellate decision involving retroactive activity, application of a constitutional rule, or the person is asserting the claim under the death penalty. And as I said before, usually what you're talking about here are claims of ineffective assistance of counsel. They're generally raised through the post-conviction relief provisions of the criminal code or Brady violations. Habeas, you don't really talk so much about habeas so much in state court. You talk about post-conviction relief. Compensation for wrongful imprisonment. If you can establish that your client was factually innocent then he has a right, and he was wrongfully convicted, you have the right to seek up to $150,000 in compensation from the Innocence Compensation Fund after exoneration at the rate of $15,000 a year, and also $40,000 for loss of life opportunities. Okay, let's plow right into evidence. Right on time here. We've halfway through the lecture. Now we're in evidence. Now, as I've already said, evidence issues generally comprise 30 to 40% of question 3. And by evidence issues, I mean issues that arise as to the admissibility of information, testimony, documents in either civil or criminal cases. So even though this is the criminal law and procedure test, since evidence is tested here, the examiners have to also have the opportunity to test you on evidence principles that would apply in a civil case. Now, does that happen often? No, almost always the evidence issues are presented in a criminal context. But there are some evidence principles that conceivably could be tested that don't relate to criminal cases. Things like the admissibility of amounts of insurance coverage, for example, or subsequent remedial measures in a product's liability case. So just keep that in mind, that everything is fair game, although almost always the evidence questions are criminal law related. Another good thing about the evidence questions is, when we get to them, I will show you 2 that are tested on every test. So once you know those 2, then we're really going through the outline looking for the random other 1 or 2 evidence questions that could possibly show up. So that's the nice thing about this. And again, the examiners have been very consistent in the types of evidence questions that they ask over the years. So that's good. Okay. Louisiana Code of Evidence is based on the federal rules, of course, very similar to it. There are some differences. You have to contemporaneously object when evidence is offered, or else you waive generally the right to object to it. Evidence could be admitted for a limited purpose. You could instruct the jury that evidence is coming in for one purpose but can't be used for another. Okay, first of all, relevance. Evidence is relevant if it just has any tendency to make the existence of any fact that matters more or less probable than without the evidence. Again, just a basic test of relevancy. Even if evidence is relevant, the trial court can exclude it under 403 if its probative value is substantially outweighed by the danger of not just prejudice, but unfair prejudice, confusion of the issues, misleading of the jury, undue delay, or waste of time. Those are sometimes known as trial concerns. Those 403 issues come up routinely in cases. Bloody pictures. If the prosecutor's trying to get in bloody pictures, well, are they relevant? Do they tend to make a fact of consequence more probable or less probable than without that evidence? Probably. You can articulate a reason why they are technically relevant. But at some point, they do start to inflame the jury. So that objection would be a 403 unduly prejudicial for trial concerns reasons objection. There are some types of evidence that are relevant, but we keep them out of evidence because of some overriding policy reason. For example, we want people to fix broken things, premises, products. So even though the fact that it was fixed is probative and relevant to whether it was broken in the first place, the rules of evidence exclude those things for subsequent remedial measures for public policy reasons. All right, what are some of these things that are excluded in both civil and criminal cases? Liability insurance. Although the policy may be admissible, the amount of coverage is excluded. Why? Because we don't want to know how chocked full of money the defendant is, or how much coverage the jury could gig the defendant for. Withdrawal of guilty pleas. In a civil case, nolo contendere pleas are not admissible. Polygraph tests, not admissible, even though they may be relevant. In criminal cases, the act of contacting or retaining a lawyer is inadmissible unless it falls within the crime fraud exception to the attorney-client privilege. All right, and that's in criminal cases only. In civil cases, we exclude, as we've already talked about, subsequent remedial measures on the issue of negligence or culpability, compromises or offers to compromise a claim, and admissions of fact made in compromise settlement discussions, offering to pay medical expenses, any amount paid in settlement or tendered for settlement, workers' comp payments. Why are all these excluded? Well, we want people to fix broken things. We want people to settle cases, so we want them to talk settlement. We want defendants to pay medical expenses and not have that held against them to show that they were liable in the first place. We want people, again, to settle, and we want people, workers, to get workers' comp claims and that not to be used against anybody to show somebody else's liability. Character evidence. What are we talking about when we talk about character evidence? Well, we're talking about evidence about who a person is or what a person has done, so as to show that if they're that kind of person, then it's more than likely that they did this act that's charged or that they're accused of doing. The overarching principle here is that in America, we believe you should be put on trial for what you did or didn't do, not for what everybody thinks you did in college or for whatever bad things you've done elsewhere or whatever reputation people have of you. Right? That's kind of just a general rule. So character evidence is evidence that's shown, that's put on to show that you are a certain kind of person and you've done certain kinds of things and therefore you probably did this too. Very suspicious of that evidence. Now, is that sort of evidence probative? You bet it's probative. If you found out that I've killed 4 people in the past and you're on my jury and trying to figure out whether I killed this poor guy, is that probative? You bet it is. But we're concerned that you're going to just say, oh, he killed those people in the past, he must kill this one. I'm not going to look too hard at this evidence. So that's the policy here that we're talking about when we talk about character evidence. Okay, so the rules regarding the use of character evidence are affected by 3 major concerns. First of all, the purpose for which the character evidence is offered, the method for proving it, and the kind of case we're dealing with. Okay. Let's talk about the purposes for offering character evidence. If we're talking about using character evidence as circumstantial evidence as to how someone probably acted, that raises the most difficult problems, particularly in criminal cases, for all the reasons I just said. If, however, a person's character is an ultimate issue in the case, like, for example, in a defamation case, I'm trying to prove that my reputation has been harmed and I'm losing money because of bad things you said about me. Well, then my character is directly at evidence in this case. That's different. We're not trying to put it on as circumstantial evidence as to whether I did some act, but that is an ultimate issue in the case. There it's got to be admitted. And as the outline says, this is only in civil litigation and very rare at that. And then finally, character evidence is often used to impeach the credibility of a witness. When would that be? Well, for example, suppose the witness has just taken a stand. He said that the defendant is innocent, was at his house eating crawfish. Well, if you're the DA, you'd like to show that this guy's been convicted of perjury 6 times. Well, that is going to be allowed, right? Because there you're showing the jurors what kind of person this is so they can draw upon his past in evaluating whether he's presently telling the truth. Okay. How do you prove character? Well, first of all, you can prove it through general reputation. And again, this is garbage testimony. But you can have somebody take the stand, and when it's permissible, and say, oh yes, he's got a reputation in the community for peacefulness, or a reputation for truthfulness. So, usually, that's the way you prove character when it's allowed to come in. And more on that in just a second. But what about specific acts demonstrating character? Can you, instead of just having a witness come and say, oh yes, he is very peaceable, can you have a witness come say, yes, I saw him petting a dog the other day, and 2 days before that he was petting a cat, and a couple days before that he was holding up a sign that said, peace to the world. Well, no. Rarely can you go into that little sideshow by putting on specific acts. Now, there are times when you can ask questions about those specific acts, but rarely can you enter into evidence, extrinsic evidence of those acts. Now, here we go. Okay. The general rules are these. In civil cases, evidence of character to prove the conduct of a person in a litigated event is generally not admissible. So, the defendant can't introduce evidence that she's a very cautious driver to prove that she wasn't negligent. Plaintiff can't introduce evidence that the defendant is a reckless driver to prove that she was reckless or negligent one day. We're going to look at the evidence and not decide it based on this garbage character evidence. Now, there's an exception when the defendant, when a party's character is directly at issue, like in the rare case, like a defamation action, something like that. Or, for example, if we've got a case, an employer is charged with negligently hiring somebody, then the character of the employee is directly at issue. Okay. What about the character of the accused in a criminal case? General rule is this, that the prosecutor cannot put on evidence that, just as we've already discussed, that this guy has a reputation for being a thief, or that he's robbed other banks, therefore he must have robbed this one. Okay, that's the general rule. Can't initiate evidence of the bad character of the defendant merely to show that he has the propensity to commit these kinds of crimes. However, the accused can do just the opposite. The accused always can put on character evidence about, for example, in a bank robbery case, that he's honest, or in a murder case, that he's peaceable. Now, the key, and this is what's always tested when it's tested, is that the defendant's character evidence has got to be as to a pertinent trait of character. So, if the defendant's charged with punching somebody in the face, he can put on a character witness that says he's got a reputation for being nonviolent, but he can't put on a character witness who's going to say he's got a reputation for being honest. It's not an honesty that's the pertinent character trait, it's aggressiveness or belligerence or whatever you want to call it. A defendant puts her character in issue by calling a qualified witness to testify that the defendant has a good reputation for a trait that is pertinent to the crime charged. That's just what we said. However, the witness can't say, in my opinion, he's peaceable. He's got to say he's got a reputation for being peaceable, or peaceful, if that's the right word. And this is important, no specific acts of conduct testimony. Can't talk about petting the dog and petting the cat and holding up the sign about peace to the world. Can only put on reputation testimony. That's so important for you to know. Now, if a defendant takes a stand and gives testimony about the facts, the defendant is not putting, is subject to impeachment, but that doesn't open up the door for the prosecutor then to put on rebuttal character evidence. Okay. Suppose the defendant does, and how does the defendant do this? He calls a school teacher or his minister, says he's a good person and he's never lies, blah, blah, blah. So the prosecutor sat through all that garbage. What does the prosecutor do next? Well, first of all, he's going to cross-examine the minister who just said he's never done a bad thing ever, never stolen anything ever. Then the prosecutor stands up and cross-examines the witness. And he can ask the witness about specific instances of conduct. He could say, oh, did you know that he has stolen from the Girl Scout troop at your church on 10 occasions? Did you know that? And he can go on over and over and over again, asking whether the reputation witness, has heard of those particular instances. Now, prosecutor's then stuck with the answer, as it's called. Prosecutor cannot prove them up by extrinsic evidence if the witness denies it. All the prosecutor does is inquire about it on cross. And that's what is at the bottom of page 4 and top of page 5. What else can the prosecutor do after that garbage testimony is put on about the reputation of the defendant for a pertinent trait of character? He can call his own rebuttal garbage witnesses who will say, no, the reputation for the defendant is one for being very bellicose or very aggressive. Okay, what about putting the victim's character on trial? Well, you can understand why the defendant would want to smear the victim, particularly in a rape case, but also maybe in a murder case. He may want to say, oh yeah, this guy attacked me and I shot him in self-defense, and let me tell you about all the bad things that this guy's done throughout his life. Now, when can the defendant do this? The defendant's got to show some hostile demonstration or overt act by the victim at the time of the offense. Now, he can't just start smearing a dead man without that door being opened by some testimony about a hostile demonstration at the time of the offense by the victim. Then the defendant can introduce reputation evidence of a pertinent trait of the victim's character, usually for violence, or evidence of prior threats by the victim against the defendant. There's a domestic violence exception that allows more of this testimony in for battered wives. She doesn't have to just show that the defendant had just attacked her before she shot him, for example. In domestic violence cases, if the defendant pleads self-defense, and let's say this is the battered wife, if the victim and the defendant were living together in a familiar relationship at the time, and they were because she's a wife, and there's a history of assaultive behavior between the two. Again, it doesn't have to be at the time of the offense, right before she shot him, but it could be further back. In this situation, evidence of the dangerous character of the victim is admissible, including specific acts of conduct by the victim. Again, wanting to let the battered wife put on more evidence of her husband's violent character. Once the defendant has introduced reputation evidence of a bad character trait of the victim, the prosecutor can counter with reputation evidence of the victim's good character for any particular pertinent, any pertinent trait. Homicide cases, again, more of the same. If the defendant pleads self-defense, evidence of any kind that the victim was the first aggressor opens the door to reputation evidence that the victim had a good character for peacefulness. The evidence can be introduced regardless of whether the defendant has introduced character evidence of the victim's generally violent propensity. Sexual assault, victim's past behavior is inadmissible. Again, this in rape cases, you generally don't want to put the rape victim on trial, right? So, evidence offered to prove the sexual behavior or sexual disposition of the alleged victim is generally inadmissible. Inadmissible. We don't want to talk about all the people that she slept with in the past. The exceptions. In a criminal case, evidence of specific instances of sexual behavior by the victim within 72 hours preceding the assault is admissible if offered to prove that a person other than accused was a source of semen or injury. Again, we're not talking about all the stuff she did back at the dorm in college. We're talking about what happened just prior to the alleged rape. Also, specific instances of sexual behavior between the victim and the accused are admissible to prove consent. You can't put on evidence of what she was wearing to show that she encouraged or consented to the offense. There's got to be some pretrial notice given if any of this evidence is going to be offered. Specific acts of misconduct. As we've already said several times, the basic rule is that when a person is charged with one crime, extrinsic evidence of his other crimes is inadmissible to prove character to show that she acted in conformity therewith. That is, if she's on trial for murder today, we don't want to let the DA put on evidence that she's murdered other people and establish that she's that kind of person, a murderer. However, that evidence of specific prior bad acts is going to be admissible if it has some independent relevance. If under 404B, it's being offered for some purpose other than to show propensity. That's all that means. What are some other things that those prior bad acts might show? Well, it doesn't matter if it fits into this illustrative list of types of evidence, but it's nice if it does. The key is it's not being offered just to show raw propensity. It's being offered to show something like motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. So, for example, suppose that all the 5 prior murders, which this guy did, were all done when the defendant painted his face like a clown and he pummeled the victim with a clown shoe in each of the 5 cases. Well, now this victim was killed by somebody dressed as a clown who pummeled him with a clown shoe. Well, under those circumstances, the prosecutor could get in the information of all those prior bad acts by the defendant to show that the guy who did this killing is the same guy who did the 4 or 5 previous killings, because it's a signature crime. It shows not that he's just a bad guy who's a murderer. It shows that it is him. It shows identity, to use the language in 404B. Other examples: motive. The commission of a prior crime may be evidence of a motive to commit the crime for which the defendant is accused. He's accused of killing Jane Doe. Jane Doe was a witness to his robbery of the Whitney Bank. So the DA can put on that he robbed the Whitney Bank to show that he had a motive to kill Jane. Why? Because she was going to testify at his trial for robbing the Whitney Bank. Intent. Suppose passing counterfeit money. The guy says, "Oh, I thought it was real money." "Oh, yeah? Well, 4 times before you've been convicted of counterfeiting." Well, again, those prior bad acts aren't being offered just to show that he's a bad guy. That would be propensity character evidence, inadmissible. But they're being offered to show that he didn't make any mistake here about passing money. He knows what counterfeit money is pretty well. He knows that pretty well. Absence of mistake or accident, again, the same sort of thing. Identity, again, signature crime. That's our clown killing defendant. Common plan, that for example, if you stole some burglary tools, that shows that you committed the burglary afterwards. Res geste if it relates to conduct that constitutes an integral part of the act or transaction, anything leading up and following from the accident, all those acts. Again, anything other than propensity. Before our break here, when a criminal defendant is charged with an offense involving sexually assaultive behavior or with a sex offense involving a kid, then evidence of his prior acts of sexually assaultive behavior or indicating a lustful disposition toward children are admissible and may be considered for their bearing on any matter to which they are relevant. Again, we're opening up this more just to show that a child predator has done it in the past and he may have done it here. Okay, let's go ahead and take a break until the top of the hour, and then when we come back, we will finish up our discussion here on page 7. Okay, let's resume. Judicial notice is when the court recognizes a fact as true without any evidence being presented on that fact. Courts take judicial notice of indisputable facts that are a matter of common knowledge or capable of verification by resort to easily accessible sources of unquestionable accuracy. If a court does not take judicial notice of a fact on its own accord, a party must formally request that notice be taken of the particular fact. Appellate courts can take judicial notice of facts. What we're talking about are adjudicative facts that relate to cases, not legislative facts that relate to lawmaking. Real and documentary evidence must be relevant. Of course, all evidence must be relevant to be admissible. Authenticity and authentication is just one aspect of relevancy. Now, the whole issue of authenticity and authentication is really simple. The whole point is just showing the judge that this document or this gun has something to do with this case, and therefore it should come in. It's really that simple. So, for example, real or documentary evidence will be admitted only if it's authenticated by proof that shows that the evidence is what its proponent claims it to be. The proof must be sufficient to support a jury finding of its genuineness. So, for example, I say, I'm the proponent of this gun, I'm the DA. I say this is the gun that was used to shoot the victim. That's what I say it is. Well, I've got to authenticate it. I need to put on proof sufficient to support a finding that this is the gun that was used to shoot the victim. So, how do I do that? Well, I could put on testimony of a witness that she says, where the witness says that the gun is what I say it is. By I mean the proponent. So she might say, oh yeah, I found that gun at the crime scene. I remember it. Or you could do a chain of custody, which is almost never done anymore, really. But you could do a chain of custody, showing that, suppose a witness looks at that gun and she says, I don't know if that's the gun that came from the scene of the murder. I just pulled it out of the evidence room and it was marked as a gun in State versus Smith. Well, then you could call another witness. The police officer says, yes, I picked up a gun and I marked it State versus Smith and I gave it to the evidence custodian. Well, there you've got a chain of custody that shows that puts forth proof sufficient to support a finding that this gun is the gun from the scene of the crime. Documentary evidence. How do you properly authenticate a document or other things? Well, all you really have to do is, again, put on evidence sufficient to support a finding that the thing is what you say it is. That's the rule. 901B then lists all sorts of ways that you can do this. Non-exclusive list, right? For example, it can be authenticated by evidence that the party against whom it is offered has admitted to its authenticity. An eyewitness can say, yes, that's what it is. You can look at the handwriting and the witness can say, yep, that's John's handwriting. Well, that's enough to support a finding that it is what the proponent says it is, namely a document written by John. If a document's at least 30 years old and it looks like it's old, then and it's found in a place where an old writing would be kept, then that's enough to establish that it is what you say it is, which is an old writing. So photographs. Photographs, you need somebody, you don't need the photographer. Anybody who's been to the place that's photographed can say, yep, that's a photograph of the crime scene, and it's a fair and accurate depiction of the crime scene. That's all you have to say. Next page. If you hear somebody's voice, anybody can say, oh yeah, that's his voice, I know it. Telephone conversations, you're trying to prove that the witness called and said that the defendant called and said he was going to murder somebody. Well, how do you know that was the defendant's voice? Well, I know his voice. Or I called his number and he answered and said that. Again, these are just the problem that most students get hung up with on authentication is they're looking for some specific rule to fit the evidence into. You don't have to do that. It's just anything that would support a finding that the thing is what the proponent says it is. It's really that simple. All of this is just by way of illustration. Self-authenticating documents. These are documents that just walk right into evidence with no witness. You don't have to put on any extrinsic evidence that the document is what you say it is. If the document has got, for example, it's a public document like a birth certificate and it's got a seal on it that you can touch or see the little gold foil, the minute you hold it up and say, this is John Smith's birth certificate, well, there it is. Because it's got that seal on it, it comes right on in. You don't need to call somebody to say, yes, this is John Smith's birth certificate. So certified documents, official publications, trade inscriptions, acknowledged documents, notes, for example, commercial paper, all those sort of certified copies of original public documents, all self-authenticating. And again, all you really need to know, and what it'll be on the bar, if it's on the bar at all, is going to be some public record that has been sealed by the custodian. And then all you need to say is, that is a self-authenticating document. No witness need be presented in order to lay a foundation for its admissibility. Best evidence rule. This rule is more accurately called the original document rule. If you want to prove the terms of a writing, including a recording, photograph, etc., the original writing must be produced. Secondary evidence is admissible only if the original is unavailable. A lot of people misunderstand this rule, but it's fairly simple. If you're trying to prove what a document says, you need the document or a copy of it. They're both the same. You can't just call a witness to say, oh yeah, our written contract says that I'm going to cut the grass and he's going to pay me $20. Well, we don't want to hear what you say about that document. We want to see the document or a copy. That's all the best evidence rule is. We're not going to have oral testimony about what some photograph shows or what's in some document. We want to see the document, the photograph. Well, I was driving here this morning. A lawyer called me who asked me to represent him in a case, a DWI, disciplinary case arising out of a DWI, and he says that he looked at the videotape with his lawyer and it showed that he was not kind of teeter-tottering around. He was walking the line straight. But the videotape has been lost. The police lost it. So now we want to prove the contents of that. I assume that we're going to want to prove the contents of that videotape. Well, we don't have the videotape. But we're going to call his lawyer who's going to say, I saw the videotape and he was not looking drunk in the videotape. Now, if the videotape existed, we don't want to hear from a witness about what's in a videotape. We want to see the videotape. That's what the best evidence rule is all about. The rule doesn't apply where, let's see, over here on page 11, secondary evidence of the contents is going to be admissible if, for example, the original is lost or destroyed, and that would be the case with our videotape. The original is in possession of a third party outside of the jurisdiction, is unobtainable. The adversary has the original can't be produced in court. And it's really that simple. The problem with the best evidence rule is people overly complicate it and never understand it. Next page. Testimonial evidence. Witness takes the stand. wants to say that the defendant robbed the bank. What do you have to establish? First of all, Rule 601 says everybody is competent to be a witness as long as they will take an oath or affirmation that they're going to tell the truth and that they have personal knowledge of the matters about which they're providing testimony. So, for example, you just can't call a witness and say, did John Smith rob the bank? Yes. Well, no, that's not appropriate. Why? Because you didn't lay the foundation that the witness has personal knowledge. The foundation would be laid by saying, were you in the bank the day it was robbed? Yes. Who robbed the bank? John Smith. Well, there you've shown that the witness has personal knowledge because he observed the matter. So the witness has to have personal knowledge, and that foundation needs to be laid. If an interpreter is going to be used, the interpreter's got to be qualified and take an oath to make a true translation. A judge, a presiding judge, can't testify as a witness, obvious. Jurors can't be witnesses in the trials in which they're sitting. However, a juror can be a witness in a matter if they're testifying about outside influences being brought into their deliberations. Form of examination of witnesses. Leading questions are generally objectionable on direct, but permissible on cross. And a leading question is one that suggests the answer. Like, isn't it true that the light was red? That's a leading question. It's objectionable if asked on direct of a non-hostile witness, but it's permissible on cross or on direct of a hostile witness. Leading questions, as I just said, are permitted on cross, prohibited on direct unless you're developing the witness's testimony. That's just getting through the small stuff. Like, okay, so you went to LSU. Yes, I did. You graduated from law school. Yes, I did. You worked for 5 years at a law firm. Yes, I did. And again, you're just developing the testimony, just moving things along. Also, if the witness is hostile or identified with an adverse party, etc., which we just talked about. Improper questions and answers. Questions that are misleading, that call for a narrative, are improper. When can a witness look at a document? You can't bring a script up to the stand, obviously. However, there are times when a witness might forget something. So if a witness forgets something, if you ask the witness, were you present? Did you see who the bank robber was? Bank robbery? I don't remember a bank robbery. Well, now you want to give them something to refresh their recollection. That's this present recollection revived, refreshing recollection. You can give them anything. For example, you might give them a piece of bloody clothing that they were wearing when they were shot in the bank. You give the bloody clothing to them, they go, oh yeah, I remember that bank robbery now. Or you can give them a diary entry. They could read the diary entry, then look up and say, oh yeah, I remember the bank robbery now, I'll tell you about it. You're giving them a document or something here just for the purposes of bringing that memory back from the depths of their memory recollection. The writing is not evidence, is used solely to refresh, just to help them jog her memory. And in my evidence class, we call this the memory refreshing thing. It could be anything, a dead fish, it could be anything. All right, now suppose that we're talking about, the witness still can't remember. Ma'am, you don't remember this bank robbery? Did you once know about the bank robbery? She says, yeah, I once knew about it, but it was years ago, I forgot. But she had written a diary entry right after the bank robbery in which she recorded in great detail what happened. Now, what you'd like to do, since she doesn't remember it, is you'd like to get into evidence her out-of-court diary statement. Can you do that? Well, where a witness states that she has insufficient recollection of the event to enable her to testify fully and accurately, even after she's looked at the writing itself may be read into evidence if a proper foundation is laid for its admissibility. The use of the memorandum as evidence of a past recollection is frequently classified as an exception to the hearsay rule What's the foundation? That she once knew about it, that she made this writing, and she made it right when it was the bank robbery was fresh in her mind, that it was accurate, that she has insufficient recollection today. Now, my example is an extreme example. Usually this is people writing down things like an inventory of stolen goods. They forgot what was stolen, but they wrote it down back then. In any event, all you can do then is have the witness read that contemporaneous memorandum into the record. The document itself doesn't come in. If a witness uses any document to refresh her memory under Article 612, the other side gets to take a look at it and cross-examine the witness about the document. Opinion testimony. Lay witnesses can give opinion testimony on things that they're rationally based on their perception. Car was going fast, he was tall. Again, those are opinions. He was upset. That's his voice. He was drunk. Again, it's all generally admissible. As to expert testimony, experts can give opinions as well. If it's a technical area or one that requires specialized knowledge, his opinion is relevant, and this is the key, his opinion is reliable. Now, that's the standard, reliability. What are some of the factors that courts evaluate in a judging whether or not the expert's testimony is going to be reliable? Well, these are the so-called Daubert factors, or the factors that are otherwise set forth in 702, things like the opinion is based on sufficient facts or data, the opinion is a product of reliable principles and methods, and the expert has reasonably applied the principles and methods to the fact of the case. The witness, next page, has got to be qualified as an expert. He's got to state that he has his opinion by reasonable probability. The opinion's got to be supported by a proper factual basis. And the opinion may even embrace the ultimate fact issue. However, in a criminal case, the expert witness cannot express an opinion as to the guilt or innocence of the accused. You can cross-examine the expert with treatises. Cross-examination. Louisiana courts allow wide-open cross-examination on any matter relevant to the case, including credibility. Criminal defendant, once he takes a stand, waives his right against self-incrimination, and he's subject to wide-open cross-examination. Credibility. Witness takes a stand, testifies. At that point, the witness's credibility is an issue. That is, by credibility we mean, is he a liar or a truth teller? You can't attack the credibility of a witness until the witness has been sworn, and it can't be supported until the witness has been attacked. Next page, any party can impeach a witness, including the party calling him. How do you impeach a witness? By asking them questions or by putting on extrinsic evidence, namely other witnesses who will contradict or otherwise discredit the testimony of a witness. Suppose a witness takes a stand and says the light was red. Can you now call, and this is the issue here, another witness to say, no, that person, or say that the witness who just testified, that person is married to the plaintiff? Well, you're putting on that extrinsic testimony to impeach the credibility of the red light, green light witness. Can you do it that way? Right? That's the only reason you're putting on that testimony. The answer is yes, because that's extrinsic evidence of a witness's bias or interest. That's always admissible. Also, if it bears on, the contradictory evidence bears on a material issue in the case. Like, for example, suppose a witness takes a stand and says that the light was red and that there was a man with a yellow hat standing at the corner at the time of the accident. Can you call another witness who will take the stand and say that the man on the corner was really wearing a purple hat? No, that's not, that's collateral. But can you call a witness to say that the light was green, not red? Yes. That not only contradicts the witness's red light testimony and calls into question that witness's credibility, but it also bears directly on a material issue in the case. So then that's okay. It's not collateral extrinsic evidence. Okay, what are the types of impeachment? First of all, prior inconsistent statements. Witness says one thing today, a couple of weeks ago in her deposition she said something else. Bias, corruption, or interest. You could always show that a witness is not worthy of belief because they like one of the parties, or they're corrupt, they've been paid off, or they have an interest. They're going to get something if that person wins. Conviction of a crime. When can you, and this is the question, let me say this. Remember I told you there are two things that are always tested? This is one of them. Always. I've never seen a bar where this wasn't tested. Never. Not even one, I'm making that clear. And it couldn't be easier. This is all you need to know. If a witness takes the stand and testifies, that witness can be cross-examined about any prior conviction, no matter what it was for and when it happened. Any crime, any time. If you just remember any crime, any time, you'll get that question right. That's a criminal case. Civil cases, a little different. Never seen them test a civil case, but at least on this issue. In civil cases, a witness may be impeached by a prior conviction for a crime punishable by death or imprisonment for more than 6 months, a serious felony. If the court finds that its probative value outweighs prejudice to a party, or any crime if it involves dishonesty or false statement. However, stale convictions over 10 years of age are not 10 years old aren't going to be admissible. Conviction can be used even if an appeal is pending. Can't be used if there's a pardon based on an express finding of innocence. Juvenile adjudications are inadmissible. How else can you attack the credibility of a witness? Show that they're a liar, they're not worthy of belief. We've already talked about their prior inconsistent statements. We've talked about their biased interest or corruption. Now, we've talked about their conviction of a crime, and in a criminal case, any crime, any time. You can also call a reputation witness. Again, this is garbage testimony, but you could call somebody who says, yeah, I know that witness, they have a reputation for untruthfulness. You can do that. Garbage, but you can do it. You could always call a witness to say that this person had no knowledge of the facts to which he testified or lacked faculties of perception. Contradictory facts. Can you call a witness to contradict the facts? This is the man in the yellow hat versus the man in the purple hat. Just as I've already said, extrinsic evidence of facts that contradict a witness's testimony can be admitted to suggest that a witness's lie on one point indicates false testimony as to the whole. However, extrinsic evidence is not permitted to prove contradictory facts that are collateral, that is, not relevant to any material issue in the case. Impeachment on a collateral matter, where a witness makes a statement not directly relevant to the issues in the case, the rule against impeachment other than by cross-examination on a collateral matter applies to bar the opponent from proving the statement untrue by either extrinsic contradictory facts or by prior inconsistent statements. Again, I've said that. That's the third time I've said that. If hearsay is let into evidence, you can impeach the hearsay declarant using the same methods of impeachment we just talked about. Witness who's been impeached can be rehabilitated through getting them just to explain on redirect, through garbage reputation witnesses about their good reputation for truthfulness. If, in some cases, prior consistent statements. Testimonial privileges. These are situations where you have some relevant evidence, but for policy reasons, we're going to allow you to keep your mouth shut and not share it with us. And that's what this is all about. That's what privileges are all about. We, of course, care about getting relevant evidence into to the finder of fact, but sometimes we care about overriding other policy, about other overriding policy concerns, and keep the evidence out even though it's probative. First privilege is the attorney-client privilege. This covers any communication between a lawyer and a client. If you're in my office and you tell me about some bad thing that you did, that's a communication between a lawyer and a client made during a professional consultation. We're not here just shooting the breeze. You're here because you need help and not you're telling me about what you did in the past. In other words, a client has a privilege to refuse to disclose and to prevent others from disclosing confidential communications between herself or her representation and her lawyer. Privilege applies to perceptions and observations of the mental, emotional, or physical condition of the client in connection with such communications. Must be an attorney-client relationship, either an actual one or one that is a prospective lawyer-client relationship. Client obviously can be a corporation, could be a client representative there. You could come of a corporation. Lawyer means someone who is either an actual lawyer or someone whom the client reasonably believed was a lawyer. Representative a lawyer can come to, like a paralegal, that doesn't break the privilege. Communication it's got to be a confidential communication, which means that it wasn't made on a public street. It was made in a way that it was not intended to be disclosed to third persons. The client holds the privilege, so the client gets to decide whether to disclose the privileged communication or not. If you subpoena a lawyer, you have to jump through certain hoops before the lawyer can be forced to testify. And there's got to be a contradictory hearing. And that's just a procedure that's set up to protect the privilege. The attorney-client privilege applies indefinitely. Even the death of the client doesn't terminate the privilege. Next page. When does the lawyer-client privilege not apply? There's what's known as the crime-fraud exception. If you come to me and say, look, I want to rob a bank, can you help me with about how to do that? Well, that's not going to be a privileged conversation. Why? Because you've come to me for the purpose of planning what you knew or should have known was a crime or a fraud. No privilege regarding a communication relevant to an issue between parties, all who claim through the same decedent. I see this a lot in my practice representing lawyers in disciplinary matters. If there's a dispute between a lawyer and a client over money, over malpractice, over a breach of the professional conduct standards, the lawyer, to protect herself, can disclose privileged communications. There's no privilege between jointly represented parties, persons. There is a privilege as between them and the outside world, but as between them, there is no shielding of privileged communications. Waiver of the privilege belongs solely to the client, and she alone can waive it. Work product is also protected against disclosure. If the attorney prepares it for his own use in prosecuting the client's case, or the client prepares it in reasonable anticipation of litigation. There is also a health care provider patient privilege that deals with communications between a doctor or a dentist and a patient. It's much broader in civil cases than in criminal cases. In civil cases, it applies to virtually every health care provider you can think of. Criminal cases, only physicians and psychotherapists. Does not apply in certain situations where it would be fairly obvious. For example, if the court orders you to go to an IME, an independent medical examination, and you show up and you tell the doctor stuff about your health, and then the doctor is going to come testify. That's the reason why the court ordered the IME in the first place. So there's not going to be a privilege under those circumstances. Privilege belongs to the patient, not to the doctor. Therefore, it's the patient's decision, not anyone else's, to disclose or not disclose it. Privileges related to marriage as a spousal witness privilege and a privilege for marital communications. The witness privilege only applies during the marriage. And the whole purpose here is to protect the sanctity and of marriage, to protect the harmony in the home while people are married. So what does that mean? Well, that means if, for example, your wife saw you rob a bank, can the DA call your wife or your husband and make him or her testify as to what she saw? No. In a criminal case, a witness spouse has a privilege not to testify against the other spouse. This belongs to the witness spouse. That protects the marital relationship from disruption. That would follow from allowing one spouse to testify against another. Again, it belongs to the witness spouse. If she wants or he wants to testify against the spouse, she can. The other one can't stop them. That immunity can only be asserted during the marriage. Then there is another privilege which exists for confidential marital communications. Suppose you go home and you say to your spouse, "Honey, I robbed a bank today." And then you get divorced. Can the DA call your ex-spouse to talk about what you said? Well, in any civil or criminal case, either spouse has a privilege to refuse to disclose and to prevent the other from disclosing a confidential communication made between the spouses while they were married. Again, this is to encourage open communications during the marriage. Both spouses hold that privilege. Either can refuse to disclose or prevent the other from disclosing. Key is, it has to be made during a valid marriage. It survives divorce. Neither one of these privileges apply in the context of domestic abuse cases. There's also a clergy penitent privilege, priest penitent sometimes called, clergy penitent. There's a accountant-client privilege. There's a limited journalist privilege. There are some informant's privileges. None of those have ever been tested. In fact, I recall a spousal witness privilege once being tested, but I don't recall any of these other privileges ever being tested. Okay. Something else that's the second thing that's almost always tested, not as much as any crime, any time, but it's this next thing: exclusion and sequestration of witnesses. And the question is usually put to you on the bar: you want to protect the integrity of another witness's testimony who is sitting in the back of the courtroom. What do? Well, you move to sequester that witness. The whole point is you want to get all the other witnesses out of the room so that they don't hear what the others are saying. So upon a party's request, the judge shall order witnesses excluded from the courtroom so they cannot listen to the testimony of other witnesses. However, that being said, a party can't be forced to leave. A person whose presence is essential to the presentation of a case, like an expert witness, can't be forced to leave, and a victim can't be forced to leave. But you just need to know that rule of sequestration just calls for the exclusion of witnesses from the trial so that when they take the stand, they haven't heard what everyone said before them. Can the judge call a witness? The court may call a witness at the request of a party or if otherwise authorized by legislation. In a jury trial, a court can call and question a witness only with the express consent of all parties made outside the presence of the jury. Hearsay. We all remember what hearsay is: an out-of-court statement offered to prove the truth of the matter asserted. So, somebody outside of court said the light was red. You would like to get the police officer who overheard the witness say the light was red to testify to what that out-of-court declarant said out there on the scene of the accident. She's not coming to court, but the cop talked to her. Can the cop come to court and say, I talked to a witness at the scene and she said the light was red? Well, no, not if you're offering that out-of-court statement to prove the truth of the matter asserted, namely that the light was red. However, there are some out-of-court statements that are not hearsay. For example, verbal acts or legally operative facts. For example, if the police officer overheard two people talking and one of them said, will you cut my grass for $10? Yes, I will cut your grass for $10. Well, if you want to prove that there was a contract between the parties, either statement can come in. Why? Because it's not being offered to prove its truth. It doesn't matter whether the person truly believed that he was going to cut the grass. What matters is that it was said. That act of saying, yes, I will cut your grass, is legally operative. It is acceptance of the terms of an offer and causes the formation of a contract. Statements offered to show their effect on the listener. For example, suppose the police officer overheard somebody say, I'm going to kill you. And later, that person wound up dead. Well, that's an out-of-court statement, I'm going to kill you. Are you offering it to prove the truth of the matter asserted? I'm going to kill you. Well, if you're offering it for that purpose, it's going to be an admissible hearsay. But if you're offering it to prove its effect on the listener, that is, that the listener went and hid in his basement, then it's not hearsay if offered for that purpose. And finally, statements offered as circumstantial evidence of the declarant's state of mind are not offered to prove the truth of the matter asserted. They're offered to prove the declarant's state of mind, not hearsay for that purpose. All right, non-hearsay statements. Prior statements by a witness. Okay, in a criminal case, the prior statement by the witness is inconsistent with his in-court testimony. The witness has been given the opportunity to admit the fact, and the matter asserted in the prior statement is supported by corroborating evidence. And, well, what's a hypothetical? Here's a hypothetical. Suppose that a witness takes the stand and says, and the DA says, were you in the bank when it was robbed? Yes. Who robbed the bank? John Smith. John Smith. Danny defendant's on trial. When the DA talked to her before trial, she said that it was Danny defendant. Here she comes at the trial and she's saying something inconsistent with something she said earlier to the police or to him or someone else. So now the question is this: can her prior inconsistent statement be offered into evidence? Now, is it hearsay? Yes. Why? Because it was made out of court, say to the police officer out in the hall, and it's being offered to prove the truth of the matter asserted, namely that Danny defendant was the bank robber. So it would seem to be hearsay. Well, is it? Well, if this is a criminal case, the prior statement of the witness is inconsistent with her in-court testimony. You bet it is. Today she said it was John Smith, then she said it was Danny defendant. The witness has been given the opportunity to admit the fact, and the matter asserted in the prior statement is supported by corroborating evidence. So we still have to have other evidence that Danny defendant was the robber. How is this relevant? I mean, if you're only offering it to prove that she said something different before, right? This is the key. You can always say, didn't you tell me earlier that Danny defendant was the robber? And if she says, I never said that earlier, then you can offer her former statement, you know, if she signed it or something, into evidence, but only to prove that she is a liar. It's relevant only on her credibility. If you want to, so the fact that whether you're not offering to prove that Danny defendant, not offering for the proof to prove the truth of the matter asserted that Danny defendant was the robber. You're offering to prove that she's a liar. The key here is you want to offer it for substantive reasons, to prove the truth of the matter asserted that Danny defendant was the robber, not just that she's a liar. And you can only do that if you've got corroborating evidence that Danny defendant is the robber. Okay, when else is a prior statement of a witness not hearsay? If the prior statement is consistent with the defendant's in-court testimony and is offered to rebut a charge of recent fabrication or initial complaint of sexual assault, or if the prior statement is one of identification of a person as someone the witness perceived earlier. This is why a lineup identification, an out-of-court lineup, if the police officer comes and say, yes, the witness pointed to number 3 and said that's him. Well, you're offering it to prove the truth of the matter asserted, namely that number 3 is the perpetrator. That would be hearsay if it was not excluded from the definition of hearsay by 801. Admissions of party opponents, very simple. At trial, you can call any witness to say anything that the adverse party, that came out of the adverse party's mouth. And that's true whether the adverse party is a human being, whether he said something, whether he adopted something by silence, whether he did it through an authorized spokesperson, whether he did it through a partner. Again, the only time the party admission rule has ever been tested has been in its most basic format, where, for example, the DA puts on proof of something that came out of the defendant's mouth. Fairly simple. Okay, bottom of page 30, hearsay exceptions. We've just talked about hearsay exclusions. What about exceptions? Well, they have those that apply when the defendant is unavailable, and those that apply whether the defendant is available or not. His availability is immaterial. When is a witness unavailable? Well, if he's dead, if he can't be subpoenaed, if he refuses to testify, if he doesn't remember what happened, if he's got some privilege. Okay, so the witness is unavailable, but he testified at another hearing. It's going to be admissible, like for example at a preliminary examination in a criminal case or at a deposition. That prior testimony can come in if the party against whom the testimony is offered, or in a civil case, a party with a similar interest was the party in the former action, and the former action involved the same subject matter, and the party against whom the testimony is offered had an opportunity at the prior proceeding to develop the declarant's testimony by direct cross or redirect examination. So, for example, a witness testifies at a preliminary examination that the defendant did the robbery. The witness is gone, can't be found. DA wants to introduce that transcript. Can he? Yes. Why? Because the party against whom the testimony is offered was the same party, the same defendant. And it involved the same subject matter, same robbery as this trial involves. And the defendant had an opportunity to develop that testimony during the preliminary examination and had a similar motive for doing so, namely to show no probable cause. So that former testimony is going to be admissible. Statements against interest. A statement of a person who's not available can be admissible if it was against that person's pecuniary or proprietary interest when it was made, and that means it was exposed him to civil or criminal liability. In criminal cases, there have got to be corroborating circumstances indicating the trustworthiness of these statements. The confession of a co-defendant implicating herself and the accused may not be admissible for confrontation reasons we've already discussed. Dying declarations. A statement made by a now unavailable declarant is admissible if the declarant believed his death was innocent, whether he died or not, was imminent, whether he died or not, and the statement concerned the cause or circumstances of what he believed to cause his death. Statements of personal or family history of a now unavailable declarant, like if your mother told you the day you were born or the day she was married and she's not around, you can testify about that. A complaint of sexually assaultive behavior made by a person under 12 is admissible if it was an initial or otherwise trustworthy complaint. The statement of a person who is now unavailable as a witness is admissible when offered against a party who has engaged or acquiesced in wrongdoing that intentionally procured the declarant's unavailability. Now, we still have confrontation issues with that. And then there's in civil cases, this omnibus or catch-all or residual exception. If the hearsay has kind of circumstantial guarantees of trustworthiness and they've had notice in advance and whatnot. Okay, hearsay exceptions that apply whether the defendant is available or not. First of all, the present state of mind of the declarant. The declarant says, "I'm hot, I'm out of breath." Those are statements of what he's thinking and seeing, offered to prove a person's intent. So, for example, if I said, I'm thinking about driving to New Orleans today, and I disappear, and the whole issue is you're trying to prove that I went to New Orleans because my wife wound up dead this afternoon. Well, the fact that I just said that I plan to go to New Orleans this afternoon is going to be admissible to prove that I plan to go to New Orleans, the truth of the matter asserted. I plan to go to New Orleans this afternoon because it's a statement of my then existing state of mind, emotion, etc. Excited utterances. An out-of-court statement relating to a startling event made while under the stress of the excitement from the event is admissible. Had a case where a witness was shot, laying bleeding in a parking lot. Police officer said, "Who shot you?" And the witness said, well, my client, Mussy shot me. And they offered it as an excited utterance. And I argued that the witness was not excited. It was very calm as they were laying there bleeding on the ground. My objection was overruled and it came in as it should have been. Present sense impressions. like 911 calls. I see the man with a stocking mask coming into the bank. Comments made concurrently with perceiving the event. Declarations of physical condition. My left arm hurts. Or you're telling a doctor, yeah, my left arm really hurt yesterday. Those are statements of either your present bodily condition, kind of just those are generally admissible. And if you're giving a report of something past, some past problem to a physician for purposes of medical diagnosis or treatment, that's going to be admissible. Business records. And again, you ought to, just for purposes of general knowledge, know the elements of the business records exception. But just any entry made in the regular course of business by people with personal knowledge, they have to make the entry at or near the time of the event that they've recorded. To authenticate the business record, you need to call a custodian or someone else knowledgeable about the business records to lay the foundation. Absence of business records can prove that something didn't happen. We've already talked about past recollection recorded. If a witness's memory can't be revived, then the witness can read the memorandum into evidence, although the memorandum itself is not going to be admissible. Public records and reports. Records setting forth the activities of an office or agency are going to be admissible. There are exceptions, important ones, like, for example, police reports. Those are public records. However, they're excluded from the public records exception. Why? What are excluded from the public records exception? Investigative reports by police and other law enforcement agencies. That's police reports, just like we've said. Investigative reports prepared by a governmental entity in a case where it's a party. Factual findings offered by the prosecution in a criminal case. Factual findings resulting from the investigation of a particular complaint or incident. Again, police reports are the only thing that ever come up on that. Records of vital statistics are admissible if reported to a public office in accordance with a legal duty. Absence of public entries in public records can show that some otherwise publicly recorded event did not occur. Certified copies of judgments are admissible to prove the truth of the judgment. Like, for example, the defendant was convicted of armed robbery. Ancient documents that are more than 30 years old are admissible. Learned treatises, if they're called to the attention of, or in civil cases relied upon by an expert witness and established as reliable by either that witness or some other expert testimony or by judicial notice. Reputation evidence, as we've already talked about, is admissible under several exceptions to the hearsay rule when they're otherwise admissible, right? I mean, there may be other rules that exclude it, but if it's admissible, it's not going to be hearsay. Because remember, if you say, he's got a reputation for peacefulness, well, you're learning that from hearing it from other people. So that reputation testimony is not going to be treated as hearsay. Statements of fact concerning personal or family history in Bibles, tombs, urns, etc., to prove the truth of the matter written in the Bible in hand, you know, like when somebody was born or something. Market reports and other published compilations, if generally used and relied upon by the public or by persons in a particular occupation. Now, just because something fits the definition or is excluded from the definition of hearsay or fits an exception, does that mean it is automatically going to come in? No, there may be constitutional problems, like Crawford, that we talked about yesterday, and that's what this is all about. This is the Sixth Amendment confrontation Crawford issue we discussed in a previous lecture. I'm not going to talk about it again, but this is, again, just a nice summary of those same issues, that there still may be constitutional problems with the admission of hearsay, even though it fits the definition of, or an exception of the hearsay rule. Okay, let's look briefly at the February 2013 examination, and look how these issues were tested back then. And the nice thing about this is this goes very quickly. You'll blow right through these questions and give only one or two sentences by way of your answer. Okay, so what's question 3? All right. At the joint trial of Nathan and Kimberly, the following events or testimonies occurred. Address the following issues that arose. Explain your answers. Okay, so first, may the prosecutor introduce evidence of Kimberly's prior conviction? Fully explain your answer. Now, she's a defendant. She's on trial. Can the prosecutor enter evidence of her prior conviction? Well, I put perhaps. If she testifies as a witness at trial, her prior guilty plea and conviction will be admissible under the any crime, anytime principle in the Louisiana Code of Evidence. If Kimberly does not testify, it is unlikely that the conviction will be admissible. I mean, then it would be just character evidence. Why else is he offering it up? Just to prove that she's a bad person. So then that would be an admissible character evidence. 2, Kimberly was arrested for possession of a firearm by a convicted felon. However, before the state can bring its charges, the U.S. Department of Justice indicts and convicts her for the same offense. Her lawyer files a motion to quash the indictment, claiming that she cannot be charged with an identical crime in Louisiana. How should the judge rule? Well, here's a double jeopardy question. This is a constitutional criminal procedure question. Rare to see this, but it's tested here in question 3. 2, the judge should deny the motion to quash. Why? Under the dual sovereignty doctrine, the double jeopardy clause applies only to prosecutions for the same criminal act by the same sovereign. The federal government and the state of Louisiana are separate sovereigns. Both can bring separate prosecutions for the same criminal act. 3, the neighbor that ID'd Kimberly died in a car wreck before the trial. Assume the initial ID process used by the detective is valid and her statement was recorded. Should the judge allow the admission of the statement and the prosecutor to play the DVD for the jury? So here we are, we've got an out-of-court identification. Answer: no, the recorded statement is inadmissible for 2 reasons. First, the statement is inadmissible hearsay. It does not fall under the prior statement's exclusion to the definition of hearsay because the declarant will not, quote, testify at the trial or hearing and will not be subject to cross-examination. Second, admission of the hearsay statement of the neighbor would deny Kimberly her Sixth Amendment right to confront and cross-examine witnesses against her. We got a Crawford problem and a hearsay problem, both there presented by trying to get in this out-of-court testimony. 4, as part of Nathan's defense strategy, his lawyer seeks to call one of Nathan's co-workers from their CPA firm to testify as a character witness. They always have these garbage character witness questions. The colleague is prepared to testify that in the community of accountants, Nathan has a favorable reputation for truthfulness. Prosecutors object to the testimony. How should the judge rule? The testimony of Nathan's co-worker as to his favorable reputation for truthfulness is not admissible. Character evidence is generally not admissible for the purpose of proving that he acted in conformity therewith on a particular occasion. The accused, however, is permitted to offer evidence of a pertinent trait of character. Nathan's character for truthfulness does not appear pertinent to any of the charged crimes. Therefore, this testimony is not pertinent to the prosecution and is inadmissible. 5, Nathan's lawyer plans to introduce evidence that Heather had a violent history and a dangerous character. Again, more of this character garbage. Should the court permit such character evidence? 5, Nathan may not offer evidence as to Heather's dangerous character. Character evidence generally is not admissible for prove conformity. Moreover, Nathan may not offer testimony as to Heather's past violent acts. Evidence of other crimes, wrongs, or acts is not admissible to prove character. While it may be admissible for other purposes, such as to prove motive, opportunity, intent, preparation, etc., Nathan seems to offer it only for purposes of showing conformity. All of that testimony is inadmissible. 6, Kimberly's lawyer wants to ensure the integrity of the prosecution's witness's testimony. What should she do prior to the commencement of trial? Again, that's one of the 2 questions they almost always ask, right? What should she do? 6, Kimberly's lawyer should move for sequestration of the prosecution's witnesses. Under that article, Article 615, On request of a party, the court shall order that the witnesses be excluded from the courtroom and refrain from discussing the facts of the case with anyone other than counsel in the case. 7. Tiffany, a member of Kimberly's church, is called by her lawyer to testify as a character witness. This is the third garbage character witness question. I don't know why they do this. They do this often. So, I mean, know the character witness rules, as stupid as they are. And also notice, this is also a little unusual, most of this so far has been evidence. That's unusual. Usually it's mostly criminal procedure, but here we're getting mostly evidence. Okay. Character evidence. 7. No, while evidence of prior criminal convictions is generally admissible for purposes of impeachment, evidence of unconvicted crimes, wrongs, or acts is not admissible to prove the character of a person. 8. During voir dire, okay, well here we finally get a criminal procedure question. A prospective juror revealed that she lived in Heather's condo building and that she had seen Heather in the building on a few occasions. They spoke to each other but never had a conversation, nor did they socialize. Are defense lawyers entitled to strike the prospective juror for cause? Answer, no. Defense lawyers are not entitled to strike the prospective juror. Challenge for cause to a juror exists if the relationship by blood, marriage, employment, friendship, or otherwise is such that it is reasonable to conclude that it would influence the juror in arriving at a verdict. Merely being casually acquainted with the defendant is not sufficient grounds for a challenge for cause. 9. During its case in chief, prosecutors called the ER nurse that attended to Heather. The nurse gave the detectives a statement while she was barely conscious. Heather stated, "I can't believe that Kimberly would do this to me." 5 minutes later, she died. Should the judge allow the nurse to testify regarding Heather's statement? Answer, yes. The statement is hearsay. ER nurse. The nurse gave, really, "I can't believe that Kimberly would do this together." Statement is hearsay and does not fall under any hearsay exception. I might have gotten this wrong. Yes. I'm right about this. Okay, this is what I say. I say that it does not fall under the exception for purposes of medical treatment and diagnosis. And that's true. Why? Because she is just, that she was injured by somebody does relate to that, but the name of the person who injures you is not pertinent to medical diagnosis or treatment, right? But it could come in as a dying declaration. The nurse says, "I can't believe that Kimberly would do this to me." About 5 minutes later, so arguably, the statement doesn't say that she believed that her death was pending. Maybe that's why I didn't go there. I don't remember. But you probably could argue that she believed she was dying, and therefore this should be admissible as a dying declaration. But the examiner doesn't say that she believed she was dying, so maybe that's why I didn't discuss dying declaration. I don't remember. But that's what I would do now. I would do the same thing, plus I would say, add another sentence that perhaps it was a dying declaration if she was under the belief that she was dying. 10, last. During the trial, prosecutors call an officer to testify about the bracelet that was later found in Kimberly's possession. The officer will testify that she actually retrieved the bracelet from Nathan's SUV. What questions should the prosecutor ask? This is just a basic authentication question. To authenticate the bracelet for admission, the prosecutor must offer evidence sufficient to support a finding that the bracelet is what the prosecutor claims it is, namely a bracelet found in Nathan's SUV. The prosecutor can lay the proper foundation for admission by calling a police officer to the stand and asking her whether she retrieved the bracelet from Nathan's SUV. If she says yes, a proper foundation for admission will have been laid. Okay, that's it. Good luck on the test. Call me, email me if you have any questions. Happy to answer them, but good luck.